With the permission of the August Chair, adorned by Honorable Dr. Justice D.Y. Chandrachud, Judge Supreme Court of India and Chairman E-Committee of the Supreme Court of India, His Lordship has joined us through video conferencing session. Although none of us who are there in this hall need any introduction to this living legend, judicial figure of our country, but I would summarily introduce Lordship, Honorable Dr. Justice D.Y. Chandrachud Sahab. His Lordship holds a BA with honors in economics from St. Stephen's College, New Delhi, and LLB degree from Campus Law Center, Delhi University, and LLM and SJD from Harvard Law School, USA. His Lordship enrolled with the Bar Council of Maharashtra and mainly practiced before the Bombay High Court and the Supreme Court of India. His Lordship was designated as a senior advocate and additional Solicitor General of India in 1998. His Lordship was elevated to the bench of Bombay High Court on 29th March 2000. His Lordship also adorned the seat of Director of Maharashtra Judicial Academy. His Lordship was sworn in as the Chief Justice of Allahabad High Court on 31st October 2013. His Lordship was elevated as Judge of the Supreme Court of India on 13th May 2016. His Lordship, along with the judicial arena, is so deeply connected with the academics. His Lordship has been a visiting professor of comparative constitutional law at the University of Mumbai and also a visiting professor at Oklahoma University School of Law, USA. His Lordship has delivered lectures at the Australian National University, Harvard Law School, Yale Law School, and the University of Witwatersrand, South Africa. His Lordship has been a speaker at conferences organized by bodies of United Nations, including United Nations Human Commission on Human Rights, International Labour Organization, United Nations Environmental Programme, the World Bank, and the Asian Development Bank. His Lordship has kindly consented to be part of this conference by addressing us all in this first working session of day 2 of this National Judicial Conference. The subject of this session is the future of justice, technology, and the judiciary, and also about improving e-Seva Kendras, Citizen Service Center for bridging the digital divide. May I request His Lordship, Honorable Dr. Justice D.Y. Chandrachud Sahab, to please deliver His Lordship's address.
Thank you, Pradiji. Very good morning to everyone today. It gives me immense pleasure to speak at the All India Judicial Conference of Chief Justices and the ICT Committee Judges of all the High Courts, organized by the Gujarat High Court. So I have great pleasure in addressing all of you, Brother Justice M.R. Shah, Sister Bela Trivedi, Justice Nazir, Brother Justice Vikram Nath, who I see in the audience, Chief Justice Arvind Kumar, my former colleague at the Bombay High Court and the Judge of the Bombay High Court, Justice Nitin Zamdar, who's also sharing this session with me, Justice R.C. Savan, all the brother and sister judges of the Gujarat High Court, and the distinguished invitees. The Gujarat High Court has been at the forefront of adopting digital reforms. The Gujarat High Court was the first to live stream court proceedings when Justice Vikram Nath was the Chief Justice. It has also kept itself abreast with technological developments relating to video conferencing and e-filing. The Gujarat High Court has also implemented a unique email facility for judicial officers of Gujarat. Judicial officers get automated email updates whenever any order is passed by the High Court relating to an order passed by them. I sincerely hope that the Gujarat High Court will continue to innovate and keep pace with emerging technologies. Today, I'm going to speak about the impact of technology on the judiciary as an institution. According to the McKinsey Global Institute, technological revolution as compared to the industrial revolution is happening 10 times faster and at 300 times the scale, or roughly 3,000 times the impact. In this context, it becomes worthwhile to explore how technology can transform and has transformed judicial processes, principles, and people. First, I will elaborate on the various initiatives undertaken by the E-Committee to not only automate but transform judicial processes. Second, I will discuss what possibilities and challenges lie in our future as judges as we continue to interact with and adopt new technology. The E-Committee's E-Courts project, which has been in its second phase since 2015, has played an instrumental role in creating a technology-enabled judicial system that could withstand the novel challenges of the pandemic. Through the E-Courts project, we managed to create a system that was conducive for virtual courts, electronic filings, and online payments. Over 3.54 billion electronic transactions were undertaken under the E-Courts project, which highlights the sheer reach and magnitude of E-Court services to common citizens. The technological innovations driven by the E-Committee can be understood through Richard Susskind's framework of automation and transformation. In his book titled Online Courts and the Future of Justice, Susskind examines two ways in which courts undergo technological changes. The first is through the process of automation, which involves small tactical adjustments and refinements, and to automate inefficient manual processes. This is incremental and evolutionary. The second is much more radical. It reinvents and re-engineers existing practices. That is, it transforms rather than automates. In Susskind's words, transformation brings disruption, whereas automation sustains traditional ways of working. Examples of automation would include appending digital signatures to judgments and orders, making them readily available to be shared with prisons, and copying branches within minutes. This also ensures that state agencies are not duped by forged release warrants. On the other hand, many other initiatives of the E-Committee have sought to displace rather than merely automate old practices. I will focus on two such initiatives, which are e-filing and digitization of court records, especially because I would like all high courts to prioritize the implementation of these two initiatives. An e-filing software application has been developed, enabling the electronic filing of legal papers and promoting paperless filing. The latest e-filing software application, version 3.0, has several novel features. It provides exchange of information and case papers, not only between advocates and courts, but also between advocates and clients. It allows online recording of oath and electronic payments. It provides several templates, facility of digital signatures, and a collaborative environment where advocates and their colleagues can work on the same file from different geographical locations. E-filing has the potential to overhaul the current antiquated system of physical filing. The system is available 24/7 and can be accessed from any location. It allows online identification and communication of defects and data extraction and categorization. It can eliminate long queues of lawyers and clerks standing at the filing counters and can avoid delays in dispensing justice in critical cases. Over 100,000 cases have already been filed online, in over 17,000 district courts and 25 different high courts. We are in the process of training advocates clerks who are vital stakeholders in the system to facilitate e-filing. The E-Committee has also taken the initiative of digitizing and scanning court records, including legacy records. A subcommittee consisting of judges and domain experts was constituted for preparing a standard operating procedure for scanning, storage, retrieval, digitization, and preservation of legacy data of courts. Approximately 31 billion court records will be digitized in the next 5 years. This initiative will work in tandem with e-filing. But if high courts do not adopt e-filing as the dominant form of filing, we will again be staring at a huge record in need of digitization. I'm happy to note that certain high courts like Orissa, Rajasthan, Chhattisgarh, and Bombay have made e-filing mandatory for government, which is one of our largest litigants. I earnestly request all other high courts to follow suit. It is also important to ensure that the electronic records generated through e-filing and digitization are accessible to persons with disabilities. Now, apart from e-filing, digitization of court records and filings is a game changer. Digitized records are easy to locate, read, represent, render, and interpret, making data entry and categorization easier. This will enable judicial administrative processes to become more environmentally sustainable by reducing the usage of paper. The judiciary is among the largest guzzlers of paper. Electronic files are also a necessary feature of virtual court hearings. The Parliamentary Standing Committee, in its 103rd report on functioning of virtual courts and court proceedings through video conferencing, has emphasized the importance and utility of virtual courts. The report notes that virtual courts can better promote the principle of distributive justice. Distributive justice requires that court services should be accessible and affordable to all. None should be disadvantaged by geographical or economic barriers or otherwise. The Parliamentary Committee believes that digital justice is cheaper and faster. People living in remote and far-flung areas can also take part in court proceedings through video conferencing and without having to spend a fortune to set foot in a courtroom. Thus, we should consider if we can put in place hybrid systems where virtual court hearings can take place alongside physical hearings so as to not lose out on the gains made during the pandemic. And I hope that the high courts will lead the front and that the Supreme Court will hopefully follow the example of the high courts. It is also important for judges to embrace technology to institutionalize digitization. The pandemic has had a transformative effect on how courts and judges function. While it is true that even within the judiciary, there were technology enthusiasts who typed away on their laptops and networked on their emails before the pandemic, they were isolated islands. The pandemic brought all of us together where keeping pace with technology became the only option. Earlier, we were not used to running our courts on the virtual platform or otherwise. Earlier, we were thus not used to running our courts or, for that matter, even offices digitally. But with the advent of the pandemic, we were required to learn how to operate our laptops, mics and cameras, how to turn on video conferencing, how to mute ourselves, and perhaps, on a lighter note, learn how to mute others. I've also seen drastic change in how my own office functions. I look at case files only on my laptop. I also write and edit judgments and orders on my laptop. I can easily access precedents and undertake legal research with a click of my mouse. My digital notes since 3 June 2020 on case files and hearings are always readily available with the press of a button. Today, my office can function completely on a virtual platform. In a similar vein, the Supreme Court has now launched the Supreme Court Interact software to make its 17 benches paperless. through the software, judges will be able to access files, annexures to petitions, and make soft notes on computers itself without it being accessible to others. All the three judges constituting my bench have adopted the electronic mode. Justice Bela Trivedi leaves me marveling at the manner in which she has all the data and information at her fingertips on the SCI Interact software, which she uses. Justice Suryakant and before that, Justice Vikramnath have also done the same thing. I saw a similar platform in the Chief Justice's court in Orissa last week when I had visited and seen Justice Muralidhar's court. So these are remarkable changes which are taking place across the Indian judiciary. But I know that my experience with technology during the pandemic is not unique. Each of you had a brush with technology as well. The statistics speak for themselves. A total of 19.6 million cases were heard by courts through video conferencing. Out of the 13 million cases registered, 8.3 million cases were disposed of, thus achieving a disposal rate of over 60%. But as Richard Susskind says, the future of courts has always extended far beyond video hearings. We are just warming up. Technology can have a transformative role to play in the adjudicatory process itself. One of the first uses of AI in the Indian judiciary was through the establishment of virtual courts for settling traffic violations and other petty offenses. Virtual courts enable the public to get their traffic challans disposed of from the convenience of their home. These courts are managed by a single judge whose jurisdiction can be extended to the entire state. Neither the litigant needs to come to the court, nor the judge will have to physically preside over it. Currently, virtual courts are operational in 12 states and union territories, including Delhi, Maharashtra, Karnataka, Tamil Nadu, Uttar Pradesh, and Chhattisgarh. The jurisdiction of virtual courts can be extended to cover insurance claims, check dishonor cases, and motor vehicle accident cases as well. The larger principle behind creating automated online adjudication platforms for certain categories of cases is to recognize that all cases that come before courts are not adversarial. They do not have to be subjected to the same level of procedural complexity. Crucially, they do not require the same investment of judicial time and resources. Our time and resources can thus then be invested in those cases where technology falls short and human intervention is truly necessary. This is what Chief Justice Sundaresh Menon of the Supreme Court of Singapore calls proportionate justice. He says that the concept of proportionality emphasizes the importance of ensuring that the nature, complexity, and cost of the solutions offered by the legal system bear a suitable relationship to the nature, complexity, and size of the legal problems before it. The Indian judiciary has merely touched the tip of the iceberg in deploying AI technologies. Around the world, AI has been used in providing automated legal advice, including the timeline of the case and the expectation of resolution by courts in Russia, China, and Mexico, to predict outcomes based on precedents, such as the software Ravel in US, the Justice Intelligence Project in Abu Dhabi, or Prometea in Argentina and Colombia, for assisting in substantive decision-making, such as sentencing decisions in the US. I believe that India can also draw from some of these experiences to ensure efficiency in the judicial process. AI can be used for summarizing petitions and for transcription of court proceedings, which could assist in criminal trials and provide an accurate description of the lower court's proceedings to appellate courts. AI can also assist the judges in combing through complex evidence and layered transactions that are common to commercial disputes these days. The volume of the filings that is produced before the courts, both on facts and law, challenges the physical and cognitive abilities of judges to identify what is of value, especially with the current workloads and resources that judges have. This influences the quality of decision making. AI can help in untangling the complexity of these cases and, really speaking, in helping judges to identify what is of value. This influences the quality of the decision making. As AI helps in untangling the complexity of cases through appropriate categorization and arrangement of evidence, facts, and legal precedents that have been produced before courts, similar tools could be useful in property disputes and criminal cases. However, a caution. We must be cautious that reliance on AI does not lead to complacency. Much of the algorithms that AI tools use are difficult to understand or explain, at times even by the programmers. AI tools employ deep machine learning. To put it simply, based on the data input, AI develops a mind of its own. However, not all data is created equal, nor is it equally available across geographies and demographics. The biggest sources of risk for data-related discrimination are inadequate data availability and biased or error-ridden data. Therefore, diversity in the data set becomes key to protecting human rights. For instance, Joy Gulamvini's research in the United States has exposed how facial recognition algorithms did not recognize the faces of Black women as human beings because the input images on which the various facial recognition algorithms were based consisted 80% of images of white persons and 75% of images of male faces. To weed out such anomalies, AI tools need to be audited at frequent intervals to identify biases and shortfalls. The state agencies, businesses, and scientists have to also be cognizant that human rights have to be integral to innovation. And this, to my mind, is really crucial. Scholars have argued that the future lies in the push for a human rights by design principle, where the scientific community commits to designing tools, technologies, and services to respect human rights by default, rather than permit abuse or exploitation as part of their business model. At our end, as judges, we need to carefully rely on these tools, especially when it comes to decision making. Judges need to independently apply their minds. AI tools can supplement the decision-making processes, but cannot replace judges. Before I conclude, I want to focus very briefly on a particular aspect, which is that the National Judicial Data Grid is a mine of data which is available to Chief Justices as well as judges across India for litigation management. But I look at NJDG just not as a litigation management tool. And I want to dwell very briefly on that before I conclude. We all know that the Indian judiciary, even today, is essentially feudal. These feudal practices are evident to us by the element of subordination which we practice amongst judges of the district judiciary. Judges of the district judiciary being made to wait when a judge of the higher court is coming into the district at the border of the district. Judges of the district judiciary are not allowed to sit when they talk to high court judges or even higher. Well, these are some of the symbols, the emblems of the subordination of the district judiciary. We need to move from a feudal to a more modern and futuristic Indian judiciary. And that change can happen only if our mindsets change. And I do believe that technology provides us with a very powerful means of changing feudal practices within the Indian judiciary. Inspection of districts, which is a source of very grave stress to our district judiciary, can be radically changed if we allow for electronic registers for inspection by the high courts. Likewise, when we assess the performance of judicial officers in the selection and promotion of judges, all the way across, I believe, not only from the district judiciary to the high court, but from the high court to the Supreme Court, we can do a lot to assuage the grievance that our processes are not objective. And we can assuage that grievance provided we use technology in an objective manner to assess those who are under consideration for higher judicial office. So I do believe that technology is full of untapped potential for changing and the face of the Indian judiciary and for making it more modern. In conclusion, therefore, I want to leave you with the thought that technology is as perfect as humans. That is, neither is perfect. Both are prone to making errors. Both have their own flaws. This does not mean that we should not strive for perfection, but it simply means being honest about the reality of decision making. And it is from that perspective that I've had a reality check in some of my remarks this morning. As Professor Upendra Bakshi, one of our prominent legal scholars, remarks, judges try, as a matter of fact, to be as objective as possible in applying and evolving principles and propositions of law, whether precedents or rules of statutory interpretation. They also, and this too is an observable fact, conscientiously admonish themselves and their brethren to follow the rationality of law. But all said and done, they do bring in their subjectivities, values, theories, dogmas, and dislikes in their decisions. If today traditional modes of dispensing justice cannot achieve a certain ideal of objectivity, neither can technology in its algorithms. Thus, what is required is the amalgamation of the best of both worlds with the only objective of increasing access to justice and reducing injustice. I'm deeply grateful to Chief Justice Arvind Kumar for having so graciously invited me for the event today. And though I'm not physically present with you, I'm present in a virtual form. But I do believe that this is really, in so many ways, a sign of the times in which we live. Thank you very much for sparing your time to listen to me and for hearing me very patiently. Thank you. Namaskar.
Obliged, my lord, for this so inspirational and futuristic address to this conference. With the permission of the chair, we would now invite the panelists, the invited resource persons to the dais to take forward the discussion of this session. Justice Nitin Jamdar, Judge, Bombay High Court, Justice R.C. Chavan, Vice Chairman E-Committee, and Mr. Ashish Shiradhonkar, Senior Technical Director, NIC, Pune, may please come to the stage and take their seats. Honorable Mr. Justice Nitin Jamdar, His Lordship was elevated as a judge of Bombay High Court in January 2012. His Lordship, being techno-savvy, has rendered services in many important committees constituted for special assignments concerning the information technology. His Lordship has served as chairman, has been serving as the chairman of the E-Committee of Bombay High Court and is also a member of the Artificial Intelligence Committee constituted by the Supreme Court of India. His Lordship has been instrumental in starting the first E-Court in Bombay High Court in the year 2013 and is also a member of Governing Council of Maharashtra Judicial Academy. Continuing with the subject of this working session 1 of day 2 of this conference, I would request His Lordship, Honorable Mr. Justice Nitin Jamdar, to please address the gathering.
Honorable Justice Chandrachud, the dignitaries present in the audience, my co-panelist. First and foremost, I want to thank the Gujarat High Court, the entire team, the Chief Justice, the judges, registry, for looking after so well. Thank you. When I received message from Chief Justice Arvind Kumar, the topic of the talk was E-Seva Kendra, I was apprehensive because I am sure everyone knows that what is E-Seva Kendra is. And nothing that I would say would be anything new to you. But then I realized the thought behind choosing this subject is that sometimes so many projects and initiatives compete for our attention that a topic recedes in background and needs to be brought in forefront. E-Seva Kendra is one such project that needs to be brought to the forefront. The E-Committee of Supreme Court, the National Informatics Center, the ministry has been working toward digitization of the justice delivery system in our country for decades. Those associated with the E-Court project are familiar with the policy and action plans. Phase 1 of E-Court project was initiated in the year 2007, pursuant to a plan prepared by the E-Committee in the year 2005. Firstly, in the phase 1, the concern was setting up basic hardware. After that, providing infrastructure. Later, with the involvement of NIC, emphasis was on software. In the year 2013, National Portal was inaugurated. More than 8,000 courts are on National Judicial Database. The case status is online. The orders and judgments are uploaded. The data of more than 2.5 crores cases is available online. 10 to 15 lakh a day use these e-court services. Their numbers are increasing every day. District courts have launched their websites. Today, steps are being taken to discontinue manual register, to replace them with electronic register. Central filing centers have been opened up, video conferencing for courts through jail, legal aid offices, etc. Case management software is deployed in district courts, taluka court, high courts. Various high courts are developing peripheral activities providing citizen-centric services. The paperless court, as the Honorable Chairman of the committee, Justice Chandrachud just mentioned, is being promoted. Scanning and digitization of digital existing record is being done. Text message and emails are being sent to the advocates to keep them informed of the status of the case. Certified copies are being given. E-filing portal is developed online. Before lockdown, video conferencing for hearing and e-filing was being explored. During lockdown, the use has increased. It's clear that the technology adopted during lockdown would not end after it is over. All in the justice delivery system have realized the convenience of using technology. But the users of these initiatives are from multiple strata in the society and different geographical location. In having access to digital services, all are not placed at the same level. Though there has been exponential growth in ownership of smartphones and broadband devices in last decade in the country, a significant gap still remains. I don't need to give statistics on number of phones, extent of broadband in rural areas, urban areas, the metropolis region, as no one can dispute that there is a difference. This is important because equality and equal access to justice are certain fundamental principles that we are adopted under our constitution. And therefore, while we make an attempt to shift the justice delivery system from analog to digital, care will have to be taken that there is no infringement of these basic principles. Transition to a justice delivery system on digital platform should not alienate a substantial portion of the Indian population from accessing it. The digital divide is a gap between those who can access digital technology and those who cannot. Digital divide will arise out of various factors: lack of internet access, lack of knowledge about digital use, poor network coverage, language difficulties, and many more. All of you are aware of those difficulties. Therefore, it's crucial that this initiative to succeed, that there is no divide between the users of digital services. When the e-court introduced case filing and case management system, it was decided to provide for a judicial service center or a facilitation center. However, the judicial service centers are meant for lawyers, court class, and informed litigants. They are typically located inside the courtroom premises, the complexes, and they primarily act as filing counters. These centers will not still cater to the needs of those who are on the other side of the digital divide. Acknowledging this position, the concept of e-Seva Kendra was born. E-Seva Kendra is quite different. E-Seva Kendras are the first point of contact between litigants and judicial establishment, those who want to access e-court related services. E-Seva Kendras are located outside the court premises. They would be set up in district courts and high court complexes. They would be manned by court administration. There can be one advocate from district legal services authority. It can include even a paralegal volunteer, even from a law school. Department of Justice has empaneled Nyay Mitras who can be associated with e-Seva Kendras. E-Seva Kendras will help litigant access necessary information. It is supposed to be paperless, would have hardware, computer, access to case information system. These services will be provided free of cost. The e-Seva Kendras will provide queries to case status, online application, including scanning of hardware copies, e-signatures. Case information can be uploaded for a litigant. File numbers can be generated. Can help online purchase of e-stamps, Aadhaar-based digital signatures. General queries also can be catered, such as location of the court, judges on leave, or virtual courts regarding traffic offenses also, e-Seva Kendra can provide help. E-committee has provided certain basic parameters for setting up the e-Seva Kendra. They are available on the website of the e-committee. Funds are allocated from phase 2 project of e-court funds. As of 29 February 2022, 493 e-Seva Kendras have been set up. Many of them are in process of being set up. Once e-Seva Kendras are set up on all court establishments, we will be on our way to effectively minimize the digital divide. E-committee has launched various citizen-centric projects, but in my opinion, the most critical initiative is the humble e-Seva Kendra. It is the e-Seva Kendra which will contribute to making digital justice accessible to all. Through the doors of e-Seva Kendra, those on the other side of digital divide will step into the technology-enabled judicial process. And it is for this reason, e-Seva Kendra deserved a special session at the conference. I'm sure all who are present today will make e-Seva Kendras an initiative which is a successful initiative. I once again thank the organizers for giving me an opportunity to share a few of my thoughts. With this August gathering, with the permission of the chair, I conclude. Thank you.
Thank you, Lordship, for the so much of information provided about E-Seva Kendras, a real powerful initiative to bridge the digital divide. At this juncture, I am tempted to share with all present here and the speakers and the August chair that when E-Seva Kendra was implemented under the then Chief Justice Honorable Mr. Justice Vikram Nath Sahab at the High Court of Gujarat, one additional value addition was done therein that the Gujarat High Court's email my case status facility was integrated with E-Seva Kendra, so that whenever a person comes to E-Seva Kendra to take status of any case, for all time to come till the disposal of the case, he would continue to get automatic email updates even without visiting the E-Seva Kendra. So this value addition was done at that time when it was implemented. I would now request our next esteemed speaker, Justice R.C. Chavan, Vice Chairman of E-Committee of the Supreme Court of India. His Lordship is in judicial service since March 1976 and has been associated with the computerization of courts for last 25 years. His Lordship was elevated in June 2005 as Judge of High Court of Bombay and retired in April 2014. Thereafter, His Lordship presided State Consumer Commission from 2013 to October 2015. His Lordship has been associated with IT initiatives for more than 2 decades and has joined as Vice Chairman E-Committee of Supreme Court of India on 2nd March 2020. I would request His Lordship to please address the gathering.
Honorable Dr. Justice Chandrachud, Chairperson of the E-Committee of Supreme Court of India, Honorable Justice Abdul Nazir, Honorable Shri Justice Vikram Nath, Honorable Judges of the Supreme Court, Honorable Chief Justices, Honorable Judges of this High Court, Chairpersons of computer committees of other High Courts, my dear friends. First, being at this place, my respectful salutations to the architect of unified India, Sardar Vallabhbhai Patel. But for him, I suppose we would have been a splintered country. It's nice that we are meeting here to attempt some cohesion in our activities in the judicial field. Gujarat High Court has been in the forefront of initiatives in the country. First, Justice Vikram Nath started live streaming. The importance of live streaming can be understood only if we imagine the type of misrepresentations that are made to clients by many unscrupulous members of the legal fraternity. True, some apprehensions have been expressed about live streaming, but all the same, live streaming will bring in such transparency that once again we may regain the confidence of the public, which is very, very important. We must not be we must not behave like ostriches, believing that everything is hunky-dory, people believe in us. No. We have to regain that confidence of the common man, and therefore live streaming is necessary. Along with live streaming, transparency in all judicial processes, availability of all judicial data to common man is necessary. And that is what E-Committee has been trying to do. Justice clocks, which Chief Justice Arvind Kumar set up, are also a reminder to us as well as common man that this is the situation and we need to work on that. As Honorable Chairperson just now mentioned, the E-Committee has been spearheading the movement of digitization of court records. In many courts, digitization has been attempted in respect of disposed of cases. My submission to all of you is that please consider putting that aside for the time being and focusing on digitization of pending cases. Because unless we stop the inflow, the backlog of digitization of record rooms will continue to grow. Therefore, let us first stop the paper coming to the courts. And this is perfectly doable. As the Honorable Chairperson mentioned, e-filing 3.0 module, which has been developed, is a perfect solution for many of the problems which we face. As he pointed out, people can work upon the same file from different places. And therefore, it becomes easy for, say, a collector, without visiting the office of the government pleader or vice versa, to finalize a draft and file it in the court. Just as in virtual courts, people appear before a virtual judge, we have a concept of affidavits and commissioners of oath. Some doubts have been expressed whether the facility of recording, video recording an oath provided in e-filing 3.0 would be a substitute for an affidavit which is to be sworn before a commissioner of oath. Now, all of us know how affidavits are sworn in the registries of various courts. It is doubtful many times whether the person who is supposed to be swearing the affidavit at all comes to the office. Here, at least, we have a guarantee that a video is recorded, which cannot be faked now. We can check up whether the person is same or not. Therefore, this is more secure than the present practice of having affidavits. And in other domains also, like register of companies. If you want to register as a director of a company, you read out an oath, you read out a declaration, not an oath, declaration on video. And that is when your application gets processed. So therefore, full use of this e-filing 3.0 facility to ensure that inflow of paper in the courts is stopped. My second submission is deviating a bit from the topic, that is e-Seva Kendras. My second submission is that the interoperable criminal justice system provides for uploading or absorbing or consuming data in respect of all police papers, all police records can be consumed from ICJS. More than half of our cases pending in all courts are criminal cases coming from the police, state machineries. If all of them are consumed through ICJS, that much paper is eliminated. Whatever little remains can be tackled by e-Seva Kendras, which are established, which provide free service to everyone in our courts. We can strengthen that network. But apart from that, again, as the Honorable Chairperson mentioned, not just today, but in the past also, because we are concerned of every component of our system. The advocates' clerks have an apprehension that this e-filing may reduce their roles and consequently incomes. Therefore, advocates, clerks have been duly taken care of, and in the e-filing module, we will be shortly enabling advocates, clerks also to file papers which normally they do in the registries. Physical papers are filed many times by the clerks of the advocates only. So same thing they will do, of course, with the permission of the advocate, with the authority of the advocate. Now, this has an advantage. E-Seva Kendras are established within the court complexes. But an advocate's clerk has the liberty to take his laptop, go to the client, and extend the services from wherever the client is located. Therefore, this limitation will go away. At least some of you may be chairpersons of the legal services authorities in the states. Chief Justices are obviously patrons in chief of the legal service authorities. Legal service authorities also can provide this facility through the legal aid clinics which are established in all law colleges. And I'm sure that legal aid, paralegal aid volunteers would be happy to do this with, of course, requisite safeguards. Therefore, the digital divide will cease to exist if we have a multi-pronged approach. If we attack the problem of paper coming to the court from various angles. This will reduce the work in the court. The chairperson mentioned about artificial intelligence also, and therefore he will forgive me for deviating a bit, digressing a bit. Once we have all record digitally available, we could put it to use by evolving artificial intelligence tools. Today, what happens is work is assigned to judicial officers not necessarily on the basis of their abilities, expertise. It is randomly allotted to them. With analytical tools, we could find out the strengths and weaknesses of officers, their abilities, and then assign work according to their abilities, reducing the levels of frustration in them also. They will be able to give better output if their abilities are fully exploited and used. Another useful fallout of digitization could be or should be intelligent scheduling of cases. Today, cases are scheduled according to rule of the thumb. Some in the High Court, some judge says, I will take 50 cases per day. Some judge says, I will take 10 cases per day, whatever it is. In the trial courts, that liberty is not there. In the trial court, somebody has already set the cause list for the judicial officer, and whether he is capable of dealing with those cases or not, he's come up before the courts. And calling matters every day in every court. At least 1 hour is spent in just calling out matters and adjourning them further. Meaningless waste of time. So all this could be avoided by assessing the case load on a particular day rather than the number of cases. It is not enough to say that 3 cases should be listed for recording of evidence. How many witnesses are going to be examined? What is the type of the witness that is going to be examined? All that matters. Even doctors are of different types. A doctor appearing to prove a simple injury certificate may not take half an hour. A doctor who has to prove the post-mortem notes in a case of dowry death may take time. So therefore, working out case load will help us in intelligent scheduling, coupled with finding out how the advocate who agrees to do that case before you is busy elsewhere. Otherwise, there are people who would agree to do a particular case or a case which is lagging behind. Every court, they will say that on 14th of April, I am available. And on 14th of April, the advocate would be missing from all courts. So therefore, intelligent scheduling will help us in avoiding adjournments, needless adjournments and wastage of time in courts. This is not all. As I mentioned, there are strengths and weaknesses of judicial officers. We would be able to find out the training needs of those officers when we send the officers for training. Right now, just as assignment of work is randomly done, we also send officers randomly for training. Many times without ascertaining whether that training is going to be put to any use by the officer in near future. And therefore, when the parliamentary committee asks us for output and outcome, we are speechless. We can't tell as to what is the outcome of this activity. Therefore, this will help in assessing training needs, evolving tailor-made programs to address those needs and make training meaningful. Another area is performance assessment of judicial officers. There also, the chairperson just now referred to that as well. Performance assessment of judicial officers is many times perfunctory because of want of time, because honorable judges of the High Court, should they be writing judgments or looking after this? But if technology can help, then the judge has to simply choose what is correct or what is not correct, and then take a call. Say, more objective performance assessment of performance of judicial officers will give a big boost, because the present method of performance assessment sometimes leaves those who are efficient at the receiving end. They feel neglected. They feel being treated on par with an average officer. So therefore, objective performance assessment will also be possible if we have entire digitized record. You need not read the judgment in entirety. Putting keywords, finding out how the judge has dealt with precedent, that can be found out by samples. So this will help in establishing a more objective method of performance assessment. Reverting back to the subject which has been assigned, namely legal service centers. Legal service centers in courts definitely help, provided we have volunteers working on those centers. Right now, we do have staff assigned, but that alone will not do. We have to engage students from law colleges who would also be enriched by their association with this activity. They will help people, not obviate, not make lawyers redundant, but they will help lawyers also to ensure that these facilities are fully utilized. Now, in many places, I'm sorry to say that these facilities are not fully utilized. And my own hometown, Nagpur, is an example where these facilities inaugurated with fanfare have not been fully used. Therefore, we have to take it up as a movement, and then alone it will be successful. If we sit in our ivory towers and expect people to come, that is unlikely to happen. It's time that we realize that confidence of the people in the system is not equal to what is reflected by media. At the ground level, the picture is somewhat different. And therefore, at ground level, we need to work hard. I request all of you to please consider vigorous effort at digitization of all records which come to the court, and to help us in evolving analytical tools so that the data which is the repository which is created is put to best use. I thank Chief Justice Arvind Kumar for giving this opportunity. Possibly for the first time I am addressing honorable judges of the Supreme Court. Since I had never practiced, I never had opportunity to address any judge. But then this is great. I'm addressing 3 judges here. Thank you.
Thank you, Lordship. So we are approaching the culmination of this session. As a gesture of gratitude, we now wish to present mementos to the honorable esteemed guests who are there on the dais. I would request Honorable the Chief Justice of our High Court, Honorable Mr. Justice Arvind Kumar, to please virtually present memento to the august chair adorned by Honorable Mr. Justice, Mr. Dr. Justice D.Y. Chandrachud Sahab. As guided and directed by my Honorable the Chief Justice, Honorable Chief Justice is handing over the memento to Mr. Ashish Shiradhonkar with a request to ensure that it reaches Honorable the Chairman of the E-Committee of Supreme Court of India.
Thank you, brother.
So, we are thankful to the chair and also to Mr. Ashish to help us in this. I would now request Honorable Mr. Justice Vipul Pancholi Sahab to please present memento to Justice Nitin Jamdar Sahab. I would now request Honorable Mr. Justice A.G. Urezi Sahab to please present memento to Honorable Justice R.C. Chauhan, Vice Chairman, E-Committee. I would now request Honorable Ms. Justice Mona Bhatt of Gujarat High Court to please present memento to Mr. Ashish J. Shiradhonkar, Senior Technical Director, NIC Pune, and HOD for E-Courts project from NIC. as directed, I am also sharing with the gathering here with a request to all the registrar ITs and CPCs who have come from high courts to please also interact between each other, as they have got this opportunity to have an in-person interaction after much of time. And also request all the esteemed guests that the souvenir which has been delivered at the places of stay of the esteemed guests has a lot of useful information, including the recent ICT initiatives taken under the leadership of Honorable our Chief Justice, Honorable Mr. Justice Arvind Kumar, and the earlier ICT initiatives taken under the Chief Justiceship of Honorable Mr. Justice Vikram Nath Sahab, which also includes the formula, gadgets, and the methodology used, including the costing for live streaming of court proceedings. So I thank all here with a request to the esteemed guests that this session is followed by a tea break at the dining place, which is just opposite to the conference hall. The tea is arranged in this hall itself, just beside the sitting place. Thank you all. Thank you to the chair to have graced this occasion today. Thank you, my lord.